Was he Gen Y, was he, sir?
Yeah, so I said, I rang him up and I said, mate, I want you to come to the office tomorrow. We have a pretty serious job.
Yep.
Haven't seen him since.
Mm-hmm.
I haven't come at all. He actually owes me $20.
I don't like the chance of you getting your $20 back, mate.
Yeah, and I thought, I actually asked Lee the other day, where's his phone number? I'll ring him and get him $20. Where do I stand with him? Is he still at is he still free to have a crack at me?
How long ago was it that he left? Or how long ago was it the last time you saw him or heard from him?
4 weeks. Yeah.
And was he a permanent employee?
No, we had him on a probationary casual basis to see how he worked out. The first week he was unbelievably fantastic. He not really come to work on a bushfire.
Right.
By the time he left, he was left the dog.
Yeah, would you like Gen Y? I have to say, there's a lot of energy at the beginning, and sometimes it tapers away, unfortunately.
Yeah, so did he come back at me and gets talking to someone in the pub or his mother or someone and say, hey, you're treated unfair?
No, the truth is, if he was a true casual employee, and I mean that in the sense that he didn't have any permanent employment in your business, he wasn't on a probationary period as a permanent, he was in fact a casual, and that meant you were paying him by the hour, and you were also paying the casual loading he must pay. If that's the case, and he doesn't come back, then in effect, the contract was terminated anyway. Because at law, a casual employee, when they finish their shift on a Thursday night and go home, technically, their contract has ended because they were casual and they are engaged by the hour. It's only once they've been with you for more than 12 months and they've worked regular and systematic hours during that time, and they also have what the law calls a reasonable expectation of ongoing employment, that they then become entitled to certain other rights.
Okay, so how long can I keep it casual?
You can keep a casual on for as long as you like. And what we also have to do is look at the modern awards, for example, because some modern awards have clauses in them referred to as sometimes casual conversion clauses, which say that after a particular period of time, if the employee has worked regular and systematic hours, he or she can then request to be made permanent, and then there will be a process that you would need to go through. But in this particular instance, you have really nothing to worry about.
And this is what really concerns me a lot of the time with a lot of clients, is the fact that I don't even know whether the employees themselves know, or are they casual, aren't they casual? They may be working, 4 days a week, pretty much every single week. And from an employer's mind, they're getting paid on a casual basis. But then also in the employee's mind, they think, well, I'm probably permanent part-time, I'm 4 days a week. And that's when things start to get a little bit messy. Where do we start? Because, there's the employer thinking one thing and the employee thinking another.
Yeah, and again, you've proven the point about why it is so important to have these things in writing, because if you don't, we all have a different idea in our minds, especially, and I'm 35, I have engaged people that are Gen X and Gen Y, and I know that sometimes my perception of what work is and those sorts of things, I have a particular idea in my mind and it's not necessarily the same as they have, so it's great to put these things in writing. And on that point about having the contract that sets these things out, one thing I should have said, when I talked about the fact that in Australia, if there is no legal requirement to have a written contract, there is an obligation under most modern awards that if you are engaging someone on a part-time basis or a casual basis, that you do record certain aspects of that employment relationship in writing at the commencement. So if you're employing someone as a permanent part-time employee, most awards require that you have a written agreement with the employee right from the beginning about what their usual pattern of hours will be over the course of their employment from week to week. And that means that even if you decide, okay, I'm not going to have a written contract of employment, you still need to record that information in writing. And again, if you breach the award, there are financial penalties for that. So all it would take is a Fair Work inspector to arrive in your workplace and say, where are your part-time employee files? You go and get them, and they sit down and they say, well, where's the written agreement that you must have under the award that specifies the average hours that they're going to work over the course of their employment? And you say, well, we spoke about it. We spoke about it when they started and everything's fine and I've not had any complaints about it. That doesn't matter to them, because the law doesn't say you have to have a written agreement unless you have conversation and it's all good. So it doesn't wash. And from a risk minimisation point of view, and that's what we're about at Workforce Guardian, just like you go to your accountant because you want to minimise your exposure and risk on the financial front, you need to do the same with your employment relations. And the best way of doing that is to dot the I's